Good evening, everybody, and welcome to the joint Kaldor Centre for International Refugee Law, Gilbert Tobin Centre for Public Law, and the New South Wales chapter of the Australian Institute of Administrative Law event tonight on the limits of immigration detention after NZYQ. I'll start by acknowledging that I'm coming to you from the unceded sovereign land of the Gadigal people and paying my respects to elders past and present of the Gadigal Nation and extending that respect to any First Nations people joining us this evening. This evening is brought to you by 3 different groups, and I would like to thank all of them. The Andrew and Renata Kaldor Centre for International Refugee Law at the University of New South Wales, Sydney, is the world's leading research centre dedicated to the study of international refugee law. Through the Kaldor Centre, I run the Strategic Litigation Network, which seeks to advance refugee protection by connecting practitioners and academics to strengthen strategic litigation relevant to refugees. If you're interested in more information about this network, feel free to reach out to me. The Gilbert and Tobin Centre for Public Law plays a prominent independent role in public debate on issues of public law significance in Australia and globally. And the Australian Institute of Administrative Law promotes discussion about the law and practice of government's action and accountability. I'm so excited about tonight's panel. We've got a star-studded lineup with Kate Bones, Barrister at Banco Chambers, who has acted as amicus and for plaintiffs in some of the leading cases we'll be discussing today, including in NZYQ and YBFZ. Next, we have Sanmati Verma, Legal Director, Principal at the Human Rights Law Centre, who's been a solicitor for many of the plaintiffs in these cases and has practiced immigration law for many years. She's also the Deputy Chair of the Visa Cancellations Working Group. Finally, we have Douglas McDonald Norman, Barrister at 8 Selborne Chambers, who has acted in similar cases as well, and is a PhD candidate here with me at the University of New South Wales, and soon to be lecturer at UTS at the Faculty of Law. Finally, I am Anna Talbot, Strategic Litigation Network Coordinator and PhD candidate with the Kaldor Centre. I'll be chairing this evening's event. Welcome, Kate, Sanmati and Douglas. This evening, we are here to talk about 3 cases from the last couple of years that have changed the direction of Australian law. As many of you will know, after 20 years of attempts, in 2023, NZYQ changed Australia's legal landscape. It overturned Al-Kateb, which had held that immigration detention pending deportation did not contravene the constitutional separation of powers. NZYQ placed much clearer limits on the constitutionality of immigration detention. The single joint judgment held that immigration detention pending deportation was only constitutionally valid if there was a real prospect of removal becoming practicable within the reasonably foreseeable future. Beyond that, immigration detention would contravene Chapter 3 of the Constitution. Since NZYQ, the High Court and the Federal Court have issued a number of important decisions that have assisted in clarifying the parameters of the NZYQ ruling, as well as ruling on the validity of the Commonwealth's various legislative responses. I'll provide a very brief overview of the 3 cases before handing over to our panel to learn what they have to say about them. We'll then have about 40 minutes to discuss before opening up the floor to questions from you, the audience. If you do have questions, please post them in the chat and we'll select some of those questions to put to our panel. Hopefully we'll have about 10 to 15 minutes for those questions. So first, the cases, and excuse me in advance for the jumble of letters and numbers I'm about to send your way. Firstly, we have ASF 17 and CZA 19, which both made rulings in relation to the validity of immigration detention. In ASF 17, the High Court held that the NZYQ limitation on immigration detention did not apply to people who chose not to cooperate with their own removal. But in obiter, people who were incapable of cooperating may benefit from the restriction on detention. In CZA 19, the High Court held that the detention for the purposes of processing visas remained valid, even if the detainee could not be removed if the visa application was refused. YBFZ focused on the legislative responses to NZYQ. In YBFZ, the High Court ruled that two of the most restrictive visa conditions imposed following release pursuant to NZYQ also contravened Chapter 3 of the Constitution, with both 8-hour curfews and monitoring bracelets being considered such a significant imposition on liberty that they amounted to a penalty and could only be imposed by a court in accordance with Chapter 3 of the Constitution. So that's a lot of information, a lot of letters, a lot of numbers to get on top of in a very short amount of time. Luckily for us, we have these three to provide us with their insider expertise on what these cases mean and what we might want to be prepared for in the future. Firstly, to you, San Marti, I've just described some of the key cases that have assisted us to understand the parameters of NZYQ and the Commonwealth's legislative responses. Can you fill us in on how the Commonwealth has responded to these decisions legislatively?
Thanks, Anna. I can definitely try. NZYQ dominated the Albanese government's legislative agenda in the migration space really during its first term. It passed with coalition support 5 key pieces of legislation impacting people both in detention and those released into the community and affected by NZYQ. The first 2 were passed in November and December in 2023 in a direct response to NZYQ, and then the final 3 were rushed through with absolutely minimal scrutiny in the final sitting week of Parliament last year. For the sake of time and the spiritual health of all of the attendees, I won't go chapter and verse through all of the new provisions, but I will give you some of the lowlights or highlights depending on your perspective. The first and most important aspect, as you've touched upon, is the introduction, not the introduction, I should say, importantly, but the expansion of the existing bridging our visa regime and the introduction for the first time of criminal penalties for breach of certain bridging our visa related conditions, attracting mandatory minimum jail sentences. Importantly, I think it's worth noting that the bridging our visa framework predated NZYQ by decades. It was in fact first introduced in 2005 specifically in response to Alcatab to respond to the situation of indefinite detainees. And as those visas were initially introduced, they were subject to 8 mandatory conditions, including in relation to residence and reporting, and they were specifically for exactly the same cohort of people, but decades earlier. After the sort of political furor after NZYQ in November and December, the existing regime was considered to be inadequate to deal with the risk that this group of people posed, and legislation and regulations were introduced, which added a further 8 mandatory and 4 discretionary conditions and introduced 9 new criminal offences relating to breach of some of those conditions, attracting, as I've said, minimum mandatory jail sentences of 12 months. The further 8 mandatory conditions were restrictive enough, including, for instance, a prohibition on engaging in work involving anything more than incidental contact with a vulnerable person, undefined. But the discretionary conditions, specifically including electronic monitoring and nightly curfew, were particularly onerous. Following the ruling in YBFZ that you've mentioned, in which those conditions were described as an extrajudicial form of collective punishment, in November 2024, the regulations were amended again to allow for the same conditions to be reimposed based on a modified test. So now, in order to impose those discretionary conditions, the minister must be satisfied on the balance of probabilities, and despite other conditions imposed on a bridging our visa, that the visa holder poses a substantial risk of seriously harming any part of the Australian community by committing a serious offence, and the imposition of the conditions is reasonably necessary and reasonably appropriate and adapted for the purpose of protecting the community from that specific risk. In 2 proceedings that I'm aware of recently filed in the High Court, EHG 19 and RCWG, the plaintiffs argue that the curfew and monitoring conditions imposed on them according to the modified test equally infract the Chapter 3 limit in the Constitution. So we'll wait and see how those matters are resolved. I understand that there are also proceedings in the federal court raising the same type of argument. So the second legislative intervention was the introduction of a power to issue what's called removal directions, basically compelling cooperation with removal and punishing non-cooperation with, again, a mandatory minimum jail term of 12 months. That was introduced in November 2024. A removal direction can be issued to a person in either detention or an unlawful non-citizen or a person in the community on a bridging e-visa who's considered to be on a removal pathway. A direction can really require a person to do a thing, anything, that the minister considers reasonably necessary to render their removal from Australia practicable. Failure to comply with a removal direction is an offence, as I've said, punishable by a mandatory minimum. I'm going to say this a bunch of times and trip over it each time. Mandatory minimum jail term of 12 months and up to a maximum of 5 years. While there's a reasonable excuse defence, the new section 199E, subsection 4, makes it perfectly clear that a fear of harm or even persecution on removal from Australia will not constitute a reasonable excuse. So the third aspect, legislative intervention, was the introduction of a power to prohibit particular items in immigration detention. That was introduced again with this suite in November 2024. It was done through a revamped version of the Coalition's old Prohibiting Items Bill, which it twice failed to pass while in government. As enacted, the legislation empowers the minister to prohibit a thing, again, anything, if satisfied that possession or use of the thing might be a risk to the health, safety or security of a person in an immigration detention facility or to the order of the facility generally. New section 251 subsection 2 specifically notes that mobile phones and internet-enabled devices might be subject to prohibition, but doesn't limit the power in that way really at all. The legislation absolutely does not indicate the degree of risk that a thing needs to pose before it is subject to prohibition. And the new provisions, from what I can see, entered into effect from 4th of June 2025, but to date, we are not aware that the minister has prohibited any particular thing or things in immigration detention facilities, but presumably that's what's going to come next. Finally, there is this recently talked about at great length, power to enter into paid third country reception arrangements, which was introduced in November 2024 by way of an expanded appropriations power at section 198 AHB of the Act, modelled on the existing appropriations power that exists in relation to regional processing at 198 AHA. So the new power allows the Commonwealth to enter into a paid arrangement with a third country, again, any country in the world, to receive a person removed from Australia. While the Commonwealth can't directly pay for a person's detention in the third country, reception functions on the part of the third state can really consist of anything involving the receipt and presence of a person from Australia, including, confusingly, if the foreign country so decides, the detention of that person according to the law of the foreign country. So in January this year, the government concluded a third country reception arrangement with Nauru, the details of which are helpfully set out or some of the details of which have recently been set out in the ruling in TC XM. That involved the receipt of 3 men who were explicitly said to be the first of a batch of people who were subject to transfer to Nauru under ongoing arrangements of this nature. The 3 men each brought separate challenges to their removal. We act in one of those matters, plaintiff S22, which is going to be heard by the High Court on Monday. Kate is instructed for us. Judgment in a second matter, as I've mentioned, TCXM, was handed down by Justice Mashinsky on the 26th of May and dismissed the applicant's challenge to the removal arrangements made in his case. And we understand that that matter is subject of an appeal. So watch that space. So that is it in a nutshell. There are many more aspects, but I will spare you from going through those for now.
Wow, okay, that's just one or two things to get on top of if you're working in this space. Moving over to the cases now, Douglas, I wanted to think about the beginnings of detention. So CZA 19 tells us that immigration detention is valid while the visa application is ongoing. Another significant reason that people have been finding themselves in immigration detention in recent years is because their visa has been cancelled under one of the various Section 501s, which can lead to new visa applications arising. Could you describe how Section 501 cancellations have been operating recently and how this potentially interacts with some of the developments around immigration detention?
Thanks, Anna. It's really important to place these contemporary controversies around immigration detention in the context of long-standing, complex legal and policy questions involving the relationship between Section 501, which permits the refusal or cancellation of visas on character grounds, and Australia's international non-refoulement obligations. That is to say, the obligations Australia has undertaken to the international community not to remove individuals who have well-founded fears of persecution or other forms of prohibited treatment under international instruments. Now, these raise complex issues. What happens if a visa holder claims to be owed protection obligations under the Refugees Convention? Or alternatively, what if Australia recognises that we owe protection obligations in respect of that person? How does Australia balance the community protection concerns that lie at the core of 501 with these obligations to the international community? And at what stage and how in the cancellation or visa application process are these distinct concerns to be reconciled with each other? Now, an initial attempt to answer these questions or provide some clarity as to their operation was found in the enactment of Section 197 C of the Migration Act through an amendment in 2014. Now, in its original form, that provided that for the purpose of the government's duty to remove non-citizens, that is to say, the government's duty to remove unlawful non-citizens under Section 198, it was irrelevant whether Australia owed protection obligations in respect of that person. This then created the spectre of a conflict between a legal obligation to remove people and Australia's broader international law obligations not to remove those people in circumstances where that would amount to refoulement. This then led to a series of complex questions about how these non-refoulement obligations are to be assessed and how they are to be weighed in this process. Are they to be assessed as part of the initial cancellation of a person's visa or in respect of a subsequent protection visa application? In assessing these questions, is the government to look solely to the risk of harm to that person if non-refoulement obligations are to be breached, as they would in a protection visa application? Or do they look to the broader consequences for Australia and Australia's national interest from that prospective breach? That is to say, the fact that Australia would be acting in a manner contrary to those representations made to the international community. These were complex legal questions and complex policy questions, which in turn made the legal questions all the more difficult. And they prompted years of litigation in the Federal Court and the High Court. Now, in light of these many years of disputation, a further answer to these questions, or a significant development in answering these questions, occurred in 2021 through further amendments to Section 197 C. This provided an important exception to the government's duty to remove unlawful non-citizens under Section 198, that an officer is not required or authorized to remove a non-citizen to a particular country if, in the course of a protection visa application by that person, it has been found that they face a real chance of persecution or a real risk of significant harm with respect to that country. And a finding of that kind is called a protection finding. Now, on one view, this answers or assists in answering some of these complex questions by providing a barrier against refoulement. But as San Marti has noted, in respect of the prospective further removals regime, and as NZYQ, CZA 19, and DND 24's circumstances demonstrate, this has yet led to yet more difficult questions. NZYQ, CZA 19, and DND 24, whose judicial review application was heard together with CZA 19, all applied for protection visas. And during the assessment of their visa applications, they all received protection findings. That is, that they would face a real chance of persecution or a real risk of significant harm if removed to their countries of origin. Those protection findings meant that as long as those protection findings remain current, they cannot be removed to their countries of origin. Now, where this barrier against removal operates and where there is no realistic prospect of their removal from Australia, NZYQ establishes that they cannot face indefinite detention. Hence, as San Marti has explored, where they cannot be detained, they may be subject to stringent conditions to monitor and control their release into the community. But CZA 19 and DND 24's cases also demonstrate that it is possible for a person to receive a protection finding and yet to face the prospect of continued detention while their visa application is ongoing, while the minister assesses whether they are of good character and hence whether their visas should be refused, either under 501 or because they do not meet a criterion for the grant of that visa. Now, these are potentially complex and prolonged questions to determine, and yet, as CZA 19 demonstrates, this nonetheless remains a permissible purpose of detention in the interim. Alternatively, if their visa is ultimately refused under Section 501 or under the character criteria for visas, their detention may be prolonged in order to explore the realistic prospect of removal from Australia to a third country. And so it is this cohort who raise complex legal and policy questions. People who cannot be removed to their country of origin, who do not satisfy or may not satisfy the character criteria, and who are waiting for a determination whether they can be released into the Australian community or sent somewhere else. And as I've noted, this raises really complex questions as to how, both at law and as a question of policy development, Australia balances this imperative of community protection with the fact that these people cannot ultimately be indefinitely detained pursuant to NZYQ.
If I could add to that, I think as well the development in NZYQ has changed the calculus in a large way for the character decisions that are made under Section 501 for people who've been found to be owed protection obligations. So where there's been many years of exploring what that means for the legal consequences for an individual in those situations, the calculus still used to need to be, ultimately, if it was considered, will this person be detained potentially indefinitely, or should they be released into the community, and balancing up the risk that the person was said to pose to the community against the very serious consequence of indefinitely detaining somebody. Now that a person in that situation cannot constitutionally be indefinitely detained, we're looking at a very different set of consequences for making decisions about whether a visa should be cancelled or whether a visa that's been mandatorily cancelled should be revoked, where instead the calculation is a person who's owed protection, if there's no real prospect of their removal to any other country, won't be able to be kept in immigration detention. They will need to be released into the community. And that is under the scheme of bridging R visas that San Martin's spoken to, with stringent conditions, with criminal penalties for breach of those conditions. And instead, there's a different question, which is for the protection of the community, for example, will the community be better protected if someone's permanent visa is restored and they have the supports that come along with that, or placed into the mechanisms of the bridging R visa regime? And are the consequences in the bridging R visa regime, which the High Court has said involve very significant infringements of liberty and bodily integrity, are those consequences imposed on a particular person, on a particular refugee, often with a background of trauma or experiencing often other mental health difficulties, are those consequences that are justified in the weighing up of a cancellation decision? And so we're really looking now for people in that group at a different calculation that's needing to be made by the Minister or delegates or the Administrative Appeals Tribunal.
Thank you both, Douglas and Kate, for clarifying what is clearly an incredibly complex area of law. And I think this background and the constant changing of policy and law has meant that people are in a whole array of different situations. Some people have protection findings but don't have a protection visa. If there's been a review at the tribunal, for example, and decisions have been made in previous frameworks that are now having consequences currently that are unforeseen and potentially unforeseeable. But Kate, your points bring us to the next case, I guess, YBFZ, where you were counsel. That case arguably has the broadest ramifications for Australian law generally of the cases that we're discussing tonight. What do you think are the significant aspects of this judgment in terms of the constitutional limits on executive power?
Well, as you summarised at the outset, Anna, YBFZ is a case not about a traditional form of detention, but rather about other forms of restrictions on liberty placed on individuals released on bridging R visas. And in particular, the case was concerned with two particular conditions, being a curfew condition and an electronic monitoring condition. As the regulations were initially made, those conditions were required to be imposed by the minister unless the minister was satisfied that they were not reasonably necessary for the protection of any part of the Australian community. That is, they were to be imposed by default unless a state of satisfaction was formed, it was not necessary. The court held in a 5-2 decision that the powers in the regulations to impose those conditions were invalid because they are properly characterised as punitive, and so they infringe on the judicial power of the Commonwealth, contrary to Chapter 3 of the Constitution. There are two particular aspects of the judgment that I will raise as significant in terms of the constitutional limits on executive power. Those are, firstly, the role of the common law in the constitutional analysis, and secondly, the requirement that there be a justifying purpose that is both non-punitive and legitimate. Before that, though, and to contextualise those points, it's useful to start with the analytical framework that was explained in the majority judgment. It was a judgment of 4, being the Chief Justice and Justices Gordon, Gleeson and Jago. That judgment, in my view, crystallises the analysis that has traced through recent Chapter 3 cases, including Ben Breaker No. 2, Jones and NZYQ. And so it's clear, clear now that that analysis involves a 2-stage inquiry, although that is ultimately directed to a single question of characterisation, which is whether the power to impose the particular detriment is properly characterised as punitive and therefore as exclusively judicial. Of those 2 steps, the first step asks, is the power prima facie punitive? It might either have that character by default, such as a power to impose detention in custody, with which NZYQ and earlier cases have been concerned. Otherwise, the first step will require looking to the substance and effects of the detriments that are imposed. And this is where the common law came in, which I'll come to in a second. The second step then is to ask whether there is justification for the power that has a prima facie punitive character. And that is whether the power is reasonably capable of being seen as necessary for a legitimate non-punitive purpose, which will be familiar from NZYQ. So in my view, what may be the most significant aspect of the majority judgment is how the common law informed the constitutional analysis at that first step of determining whether a power is prima facie punitive. The majority connected the doctrine of the separation of powers in Chapter 3 of the Constitution with our common law tradition that has long recognised the basic rights of human life, bodily integrity and liberty. And those are ancient principles of the common law that were recognised to underpin our Constitution and predate it. And their honours said that the doctrine of the separation of powers and the common law rules protecting a person's liberty and bodily integrity spring from the same underlying values. What this means is that those basic common law rights, to repeat them, life, bodily integrity, liberty, give some content to how to evaluate the substance and effect of the detriments that are imposed by a power to ascertain whether they're prima facie punitive. So applied in YBFZ, that meant that 2 new forms of detriment were found to be punitive. For the curfew, as Anna mentioned, that was a requirement to remain at a notified address for 8 hours of every day. The majority said that it wasn't necessary to deal with the question of whether that amounted to detention in custody to attract the default characterisation as punitive, where some arguments had been put about the alignment potentially between that concept and the concept of false imprisonment, a common law. But it wasn't necessary to reach that because whether or not it was detention in custody, the majority found that the curfew condition involved a material deprivation of liberty. That is, it imposed detention for a third of every day. And it was significant in that analysis that the person was confined because they would commit an offence by leaving the address. The application to the electronic monitoring condition is an even more significant extension in my view, because it is much further away from the traditional notion of detention that has been the province of Chapter 3. The electronic monitoring condition was prima facie punitive in the majority's analysis because of the interference that it involves with bodily integrity. That is by what is quite a bulky device being affixed to the person, meaning that the power authorised what at common law would otherwise be a battery. And it also involved an involuntary restraint on liberty because of the practical constraints that the onerous charging requirement, I think twice a day for about an hour, had on constraining a person's movement in the other times. So this analysis founded in common law rights is significant, in my opinion, because it has the potential to open up what kinds of restrictive measures imposed on people might be prima facie punitive. And the reason that that matters is that it's the first step that gets you in the door for Chapter 3 scrutiny, and that means that the power requires justification. Turning to the second aspect, which is a shorter one, at the second step of justification, the majority judgment makes clear that the identification of a justifying purpose needs a purpose that is both non-punitive and legitimate, and that legitimacy requirement has work to do. The purpose of the power in issue in the case was identified as being that was stated in the provision, which was the protection of any part of the Australian community. That didn't suffice as being non-punitive because the concept of protecting the community is so elastic that it is not inconsistent with the imposition of punishment. But importantly, in my view, the majority considered that even if the words protection of the community from harm could be read in, a purpose at that level of generality wouldn't satisfy the legitimacy requirement. Rather, what's needed is the identification of a specific form of harm, such as the harm that is caused by terrorism. And the majority said that if protection from any harm of any nature, degree or extent were sufficient, the very point of a legitimacy requirement would be undermined. And the significance there is that that provides an important limitation on what purposes might justify significant forms of restriction on liberty.
As a common lawyer, I love to see those kinds of principles being spread around to other areas of law. So I think those insights are absolutely fascinating. Thank you, Kate. Just a reminder, if you do have questions about anything you're hearing, feel free to put them in the chat throughout, and we'll come to them in about 10 minutes or so, 10 to 15 minutes. So coming back to CZA 19, Douglas, these cases have contributed to understanding when detention is valid. Are there any guardrails around the validity of detention while visas are being processed?
So some of the biggest remaining questions in this area are ultimately questions of time in respect of both detention, but more broadly in respect of rights and responsibilities under the Migration Act. What impact does a lapse of time have on a person's rights and on the corresponding powers and responsibilities of government? Now, time was critical to the High Court plurality in CZA 19's emphasis that detention, even within the scheme permitted by that judgment, is not unlimited. And in doing so, adopting the language of an earlier High Court majority in AJL 20, the High Court plurality in CZA 19 reiterated the existence of what is termed hedging duties, that the Australian government is subject to duties under Section 189 to take an unlawful non-citizen into detention, to under Section 196 to hold them in detention until they are removed from Australia through various mechanisms or until they are granted a visa, and under Section 198 to remove them from Australia once certain conditions are satisfied. And these duties are enforceable by writs of mandamus. And so in the High Court's analysis, a person therefore cannot be indefinitely detained. Mandamus can be sought to compel the performance of these duties to remove, and if a person has reached a point at which they must be removed, and yet that duty to remove cannot be performed other than through an applicant's own default, then that is the point at which, in the absence of a realistic prospect of removal, following NZYQ, they must be released. Furthermore, critically, mandamus can require the performance of these duties within a reasonable time. Indeed, where there is no remaining valid basis on which a visa application may be refused, the High Court's 2015 judgment in Plaintiff S297 establishes the availability of writs of peremptory mandamus to command the grant of a visa, where there is no lawful basis on which that visa application may be refused. Now, what is a reasonable time for the performance of each of these relevant hedging duties does not permit a single hard and fast answer. What is reasonable in a given case in terms of the assessment of a person's visa application, in terms of the exploration of the possibility of third country removal, in terms of how these various hedging duties may be performed, ultimately turns upon the circumstances of an individual applicant, the way in which their visa application refusal or cancellation has progressed, and various potentially idiosyncratic steps in that process, and what has been done to facilitate their removal, including to a third country. These are complex factual questions. And while litigation is potentially a very important way of answering these questions, they also ultimately require a collaborative approach between detainees' representatives and the department to consistently monitor and assess whether and when these thresholds have been reached. Litigation is part of the mechanism by which these hedging duties are ultimately enforced, but not of itself necessarily the exhaustive solution. Now, these questions about time operate in conjunction with broader debates about whether and when the minister's powers to refuse or cancel visas under the Migration Act can be exhausted by the elapse of time. And so in Justice Horan's very recent judgment in XMBQ and the Minister, His Honour found that the Minister's discretionary powers under Section 501 A to set aside a tribunal decision and cancel a person's visa in the national interest had not been exercised within a reasonable time after that tribunal decision, and hence that decision was beyond power. Now, I'm without expressing a view on the merits of that judgment or prospective future of that judgment, I know obviously that turns upon the particular facts of the 3-year delay between decisions in that case. It ultimately reinforces that the reasonableness of time is to be determined by what has been done in the interim and what remains to be done in future. But this is nonetheless a significant development because it demonstrates this evolving understanding of how questions of time and delay are potentially significant constraints on ministerial powers and discretions in this field, not just upon detention, but upon the broader regime of cancellation and refusal powers that potentially lead to these complex detention scenarios that I noted in my previous answer. And so the extent to which delay is potentially a constraint upon these cancellation and refusal powers is an evolving question to which further answers are ultimately going to be provided in a matter of time.
Kate, did you have something to add to that?
Did my face give me away? Yes, could I echo on the importance of mandamus as the route, the endorsed route for seeking to enforce the limits of detention when a visa application is being processed. A small detail in CZA 19 that I think is potentially of use there is that the majority at paragraph 53 of the judgment referred to the need for a decision to be made on a visa application as soon as reasonably practicable, describing that as an implicit temporal requirement by reference to plaintiff S4 2014, that is sort of drawing from the same constraint that removal must be effected as soon as reasonably practicable, that also implicitly conditions how quickly a decision needs to be made on a visa application. It's possible that gives a slightly more rigorous starting point for mandamus in relation to delay in decisions on visa applications. And in my view, that remains an important route that is securing the release of people who've been detained long term, because many in that category are people waiting on a visa application decision.
Thank you. That brings us to the final of the three cases that we are here to discuss tonight, ASF 17. San Marty, that case tells us that detention is valid if a person is not cooperating with their removal from Australia by choice. But in Obiter, it said that detention may not be valid if a person cannot cooperate with their own removal. Where does that leave us? What are some of the variable issues around choice that the court seems to have hung its decision on in ASF 17?
Thanks, Anna. So ASF 17 touched on a unhappy sore point in the joint judgment in NZYQ, which in turn picked up the court's comments in plaintiff M47, which was an earlier failed attempt to overturn Alcatab. The court found unanimously in ASF 17 that ASF 17 had voluntarily frustrated lines of inquiry relating to his removal so that it could not be said that there was no real prospect of his removal becoming practicable in the reasonably foreseeable future. You've outlined in introduction the facts of that case, but in summary, the plaintiff was an Iranian man who'd been refused protection through the now defunct fast-track process, but who maintained that he feared persecution in Iran and therefore had a good reason not to cooperate with efforts to remove him. It was accepted by ASF 17 at trial, importantly, that had he volunteered and voluntarily cooperated with the processes proposed by the Iranian authorities, that his removal could have been effected. So in assessing whether the constitutional limit on ASF's detention had been exceeded in that case, the court held unanimously that continuing detention for a non-punitive purpose that is occurring because of a voluntary decision of the detainee cannot be characterised as penal punitive. So that distinguished the circumstances of our client AZC20, who was given leave to intervene in ASF 17. AZC20 is also an Iranian man who was refused protection through the fast track and had also refused to cooperate with his removal to Iran, resulting in his detention for close to 11 years. But weeks after orders were made in NZYQ, Justice Kennett granted a writ of habeas corpus on the basis that our client, largely because of the effect on him of prolonged detention, no longer had the capacity to cooperate with efforts to remove him. So between those two polarities, between voluntary action on the one hand and complete incapacity on the other, there's the vast grey area encompassing the real psychological barriers that prevent people, especially in long-term detention, from cooperating with what can be really complicated removal efforts. There is, which I think is an area open for exploration, the profound effect of past trauma, which even if in a protection process has been found to be unlikely to recur, itself still poses a really serious psychological impediment to people's return to their home country. And there's, I think, sort of zooming out, a real risk in the cases that freestanding notions like voluntariness or non-cooperation or even capacity become sort of a stand-in for the real constitutional test, which, as we've said ad nauseum, centres on whether there's a real prospect of removal becoming practicable in the reasonably foreseeable future. So you see in cases like GMZ 18, for example, that the Commonwealth maintained that the applicant's non-cooperation was the only obstacle to his removal to Iran, even while conceding in the same case that the applicant had been found to be owed protection through an internal departmental process, and it was contrary to policy that he be removed to Iran. So the non-cooperation became this freestanding sort of notion to fix upon. I think two cases handed down after AZC 20, but before the High Court decision in ASF 17, illustrate the importance on maintaining focus on the formulation of the constitutional limit in NZYQ, and they are Adam and David, both represented by the ASRC. The applicants in both matters, again, were Iranian men who had been refused protection but had not volunteered to deal with the Iranian authorities to facilitate their return. But what they put in issue in those cases was the causal link between that non-cooperation and the ultimate practicability of their removal. So to put it another way, they claimed that even if they had cooperated, it was not clear at all that the Iranians would permit them to return. And the court held in both cases that the Commonwealth had not discharged its burden by making out what the Iranians were ultimately likely to do. So I think that these are live questions that require thought, considering that Iranians now constitute the second largest group by nationality of people in immigration detention, at around 7% of the detained population. The department has stopped giving nationality-wise disaggregated statistics, but at least from experience, I can say that some people in extremely long-term detention happen to be Iranian nationals. And it is perfectly clear to us from our experience after ASF 17 that the department has introduced no process whatsoever to even assess people on the bare basis of their capacity to cooperate with removal. For instance, we've acted for clients who are subject to guardianship orders, for instance, and who, in relation to whom no steps have been taken, either to bring about their removal from detention or to progress their dealings with the Iranian authorities whatsoever, even after the guardianship orders have been made. So I think that group of people, are going to have cases that require much greater scrutiny, both in relation to the capacity question and the voluntariness question, but also in relation to, precisely what are the procedures of the Iranian authorities for facilitating return, because I'm not quite sure that has been firmly established in any of the cases on the evidence. And frankly, I'm not quite sure whether it's clear to the Commonwealth.
Okay, so there's a lot of questions still to be answered. And it'll be interesting to see how that goes. We've got about 14 minutes left. I did have one further question, but I might go to a couple of the audience questions first, and then if we've got time, I'll come back to the final question that I had. I'll ask the first two questions together. They're good questions for the panel, probably starting with you, Samarty. Firstly, could the minister's potential prohibition of a thing or things in detention be applied only to specific groups or to an individual? And secondly, following NZYQ and YBFZ, what would you say is the relevance of proportionality testing in determining whether executive detention breaches Chapter 3? So firstly, Samarty, would you like to have a go at the first question?
Yeah, sure. I think that there are a range of ways in which the 251 capital A power could be exercised in a manner that was pretty pointed or brought about group-based or individual-based results, albeit that the power itself is directed the prohibition of a thing or things. So, of course, there's nothing to prevent the power to be exercised to prohibit or to cause the prohibition of a thing that is only in the possession of one person, or the type of thing that is only in the possession of a group of people. That could well be done. Alternatively, the result of the prohibition of a thing, it brings about a series of consequences. So increased search and seizure powers, including the power to strip search in relation to particular things. And so even if the thing itself that was prohibited was in the possession of multiple people, it is quite possible that the search and seizure powers, for instance, could only be exercised in relation to a particular subgroup or a cohort or even an individual. So I mean, we're obviously watching very, very closely for when notices of prohibition are issued. None have been yet, but as I said, the legislation has only been in effect for around a week or so. So we're watching and waiting.
Thank you. And I don't know, Kate or Douglas, did either of you want to have a go at the question about proportionality?
I will, unless Douglas wants to.
Fantastic.
So the role of proportionality and also what kind of proportionality we're talking about was dealt with in a bit more detail in CZA 19, and in particular the intervener in that case, represented by counsel who I think might be online, argued that the analysis should proceed using a structured proportionality analysis. Where I think we land in sort of very brief summary form after that judgment is that for the Chapter 3 analysis, the type of proportionality that we're talking about is the reasonably capable of being seen as necessary test, which is understood, and reasonably necessary is understood to mean reasonably appropriate and adapted. And in how the majority understood that in CZA 19, the answer that provides or that provided the connection for being reasonably appropriate and adapted came from the scheme of the Act. So it really is a focus on the legislative provisions and what boundaries they give, rather than necessarily what might be a more rigorous proportionality analysis that, for example, might ask whether the same end could be achievable by other means, which the majority said was no answer, because obviously there could be arguments to be had about whether detaining somebody for the reason, for the purpose of processing their visa is necessary in the sense of an appropriate way to achieve the end of what was identified there as maintaining the integrity of the process by preventing someone from absconding or for performing checks. It can readily be seen that in a lot of cases that's not going to be necessary in an individual case. But the focus is on what connection can be found in the legislative scheme. And I think YBFZ demonstrates that analysis as well. The majority didn't need to, but went on in obiter to say that even if there had been a legitimate and non-punitive purpose, the power also would not have been reasonably capable of being seen as necessary for that purpose. And that's essentially because the way that the power was structured in the regulation broke the rational connection. And that's because it could have been required to be imposed on somebody in the absence of information that it was necessary, or simply because the minister wasn't able to form a state of satisfaction that it wasn't. And so the fact that it could end up being imposed without being reasonably capable of being seen as necessary operated to break that reasonably appropriate and adapted connection.
Thank you, Kate. That's very helpful clarification on that issue. I'll quickly go back to our final question, because I think you've just touched on the point that I was going to ask before I went to audience questions, which is about, and what San Marty mentioned in one of her first responses, actually, the regulations, the way that the regulations were amended following the judgment in YBFZ, that those regulations provided for a new power to impose curfew and electronic monitoring conditions. Where does that leave this cohort? Are they back in the same position that they were in prior to the judgment in YBFZ, or are they somewhat more protected than before?
Yes, I guess on an immediate impression, when there's a constitutional victory in the High Court and an amendment on the same day to allow those conditions to be reimposed, that does raise the question. But no, as San Marty set out at the start, the test now that is required to be met in order for the minister to impose the curfew or the electronic monitoring condition is now a much higher bar. It has a lot of components. It's very wordy. So that includes that the visa holder poses a substantial risk of seriously harming any part of the Australian community by committing a serious offence being defined in a particular way, and that the imposition of the conditions is both reasonably necessary and reasonably appropriate and adapted for the purpose of protecting the community from that harm. What that means in practice is that those conditions are imposed on a whole lot less people now. So the latest numbers I've heard were reported in around December, so no doubt it's shifted since then. But that was after the new regulations were made. And at that stage, it was reported that there were 37 people subject to the curfew and 64 subject to electronic monitoring. And that was out of, I think, a cohort by that stage of about 280 people. So that is a much lower number than where we started out, which was that initially, and Sam Marty will correct me if I am remembering this wrong, but that at the start, those conditions were imposed on almost everybody. The second reason that I think we're in a different situation here is that that test, being a complex test, involves a difficult assessment of a kind that is routinely required to be made by state Supreme Courts under legislation for state post-sentence supervision or detention order regimes. And in my opinion, it's not one that's well suited to an administrative process without procedural fairness being made by delegates of the minister. And the upshot of that is that I think judicial review is now an important route for supervising the legality of those decisions being imposed on people. Just straightforward judicial review on administrative law grounds, asking is the test being applied correctly and reasonably, is relevant information being considered? And those proceedings, as I'm seeing them, are often prompted by criminal charges being brought against an individual, because at that stage, the legality of the imposition of the conditions really crystallises in importance, because it's only if the visa was validly granted and those conditions were validly, lawfully imposed, that the charges against a person can be made out and that they then are liable to imprisonment. So I think that remains a developing area, the judicial review of those decisions.
Okay, there's yet another developing area. I mean, this area of law is just such a battle between the courts and the executive so often, with the judgments coming down and then the regulations changing, and it's just constantly evolving so quickly. We've probably got time for one more question. We could try and squeeze in two, but it might be tight. But I'll start with this one for San Marty. In circumstances to ASF 17, for those who are unable to cooperate with their deportation due to mental incapacity or psychiatric illness, what would be the next process or recommendations for them when it comes to mandatory removal pathways?
Is it cheeky to say instruct Kate? I think, like I said, it has not been my experience in recent cases concerning people from Iran that the department has instituted, or the Commonwealth has instituted, any super complicated process following ASF 17 to form its own view regarding the capacity or incapacity of people in long-term immigration detention. One can infer from that they take the view of ASF 17 that, everyone who's kind of uncooperative with their own detention, has the obligation of putting on, or the burden of putting on, evidence their own incapacity, and save for that, their detention is lawful. I assume that that's the position that's being taken. I think a combination of seeking evidence regarding their current state of capacity, if time permits, seeking the background documents that inform any view that the Commonwealth has formed of their capacity or incapacity or otherwise. But most importantly, like I said, keeping in issue what precisely is the position of the Iranian authorities, because I think every available statistic tells us that, cooperation or non-cooperation aside, it is very difficult to predict what Iran and states, similar to Iran, will do when faced with the prospect of receiving their own citizens following a lengthy period overseas, or particularly where they've committed certain offences and they're not in possession of their own identity documents. I think that kind of remains an open question. And there's a lot of, I think now one can piece through, so, Adam and David and AZC 20 and a series of other cases, one can sort of piece together some of the problems that the Commonwealth itself has encountered in the process of removing Iranians, in particular, if we're talking about there. Iran's not the only country where there are barriers with accepting involuntary removals. Vietnam is also such a case, and other states have very, very particular barriers. But I think not accepting that non-cooperation is sort of a brick or a determinative barrier, as the Commonwealth would have it, and really getting to the bottom of, well, what role does cooperation play in the ultimate question, which is the practicability of removal. That's sort of where we need to start.
Sorry, I failed to unmute myself. Well, tragically, I think that's all we've got time for. I would love to keep chatting over this with the three of you all evening, but we're in different cities and the time is up for our webinar, unfortunately. I'd just like to thank you all so much for taking the time out to speak to me and to our audience about these cases this evening. I'd like to thank the three organisations that have co-hosted the event as well, the Kaldor Centre, the G&T Centre and the Australian Institute for Administrative Law. I've learned so much. I hope that everybody else has as well. We haven't even gotten to some of the big developments that have been mentioned throughout tonight. The Nauru removals, for example, the case of TCXM. These are all going to be unfolding over the next while in the courts. So we may well be back to discuss some of those developments in the not too distant future. But until then, thank you so much for taking the time to join us this evening. Good night.
Thank you.
Thanks, Anna.